Ron, I'm looking forward to you explaining this one to me because, well, not many people seem to understand what the heck Disney is up to here. Let's dive in with it. This is by Imran Rahman Jones, and it's out of the BBC. Disney Plus terms prevent allergy death lawsuit, says Disney. It says Disney. Disney World is arguing a man cannot sue it over the death of his wife because of terms he signed up to in a free trial of Disney Plus. And folks, if this seems difficult to believe, just understand we also find it hard to believe that Disney is actually trying this. Jeffrey Piccolo filed a wrongful death lawsuit against Disney and the owners of a restaurant, that being Raglan Road, after his wife died in 2023 from a severe allergic reaction after eating at the theme park. However, Disney argues its terms of use, which Mr. Piccolo agreed to when creating his Disney account in 2019, means they have to settle out of court. We are deeply saddened by the family's loss and understand their grief, Disney said in a statement. Given that this restaurant is neither owned nor operated by Disney, we are merely defending ourselves against the plaintiff's attorney's attempt to include us in their lawsuit against the restaurant. Ron, my question to you, as someone who practices law and has no doubt guided and consulted people on legal pathways forward, why would Disney simply not say that in their defense? Why in the legal filings do they go to such a crazy extent as to say, well, you had Disney Plus once upon a time, you just had a trial of it, and you had it for a month, but that's good enough. You can't sue us. Should people who have had the Disney Plus service or the Disney Channel, or maybe they walked into a Disney store back in the early 90s, should people be worried that Disney can off them and there's nothing they can do about it? What's really going on here, Ron?
Well, first, one thing we're going to make very clear is that the article saying that the agreement requires that they settle out of court instead of going to court. Going to arbitration is not settling out of court. It's just a private court as opposed to a public court.
Who chooses in arbitration who the arbiter is?
The party that writes the arbitration agreement.
So it would be advantage Disney.
Advantage Disney. But the answer to your question is no. It is a very remote and far-fetched arbitration demand or motion to compel arbitration. It is true that if you agree, click-wrap licensing and all the stuff that we click through and ignore when we install software, when we download software, and when we buy tickets online, all that kind of stuff, that's enforceable. Two big buts. First of all, it's enforceable to the extent that the arbitration governs the relationship that is defined by that contract, by that user agreement, not any conceivable interaction you might have with the other person. And surely, one of the things that we talked about the other night was that kind of arbitration is only going to be enforceable against a person who knowingly agreed to it. In this case, the plaintiff is the estate of the unfortunately deceased wife. The estate stands in the shoes of the wife. She did not ever have anything to do with any of the arbitration agreements. I think there are two that they're trying to rely on here. It's just a kind of a Hail Mary, some ambitious young lawyer's idea of which was obviously passed on by someone senior, of, belts and suspenders, let's not let any stone go unturned. So
we've got two far-fetched angles coming from both sides of this, in my estimation. On the one side, we've got Disney making the claim that because you were enrolled in the Jelly of the Month Club, you can get killed and who cares? On the other side, you've got this husband is suing Disney, and Disney is not the owner of the restaurant. There are some suggestions, perhaps, that Disney shouldn't be part of this suit. Others say, well, maybe there's something we don't know about. Maybe Disney Springs has protocols that slow down emergency personnel. Don't know that. It's just a theory, just speculating. Some people say, well, maybe Disney enforces their restaurants, all the leasers to have allergen protocols that didn't work here. Or maybe it's just as simple as Disney suggested this restaurant on one of their apps. And so, they get sued for that. We don't know.